meeting of the Municipal Officers Electoral Board of the Village Park Forest. I am Mayor John Ostenburg, Chairman for the Electoral Board. Also serving on the board is the Village Clerk, Sheila McGann, and our second Senior Trustee Robert McCray. Mr. McCray is serving in place of our Senior Trustee Mae Brandon, who is seeking election or office in this election that's under consideration here, and as such is being replaced by Mr. McCray since the law does not permit her to participate. At this point, I would ask the village clerk to call the roll.
Mayor Ostenburg.
Here.
Trustee McCray.
Here.
And I'm Clerk McGann, present.
Okay, very good. I also want to introduce Ross Secler from the firm of Odelson and Sterk. They are attorneys for the Village of Park Forest. Mr. Secler will be serving as the attorney for the Electoral Board. And at this point, I would ask him to explain the rules of procedure, and then we'll move to a motion in that connection.
Thank you, Mr. Mayor. The rules of procedure and the proposed draft rules are, there are copies available on each party's tables. But the rules are based off of the common rules applied by the Chicago Board of Election Commissioners, the Cook County Officers Electoral Board, as well as the State Officers Electoral Board. Obviously made to be in a village in municipal context, but these are the commonly used rules and procedures to help expedite these proceedings, given the need to certify the ballot very quickly and to get through these matters very quickly, but at the same time being as fair as possible to both parties and ensure this.
Very good. Is there a motion to adopt the rules of procedure?
I move that we adopt the rules of procedure stated.
Second.
Second.
It's been moved and seconded to adopt the rules of procedure. Any discussion among the members of the board? Then let us proceed to the vote. Will the clerk call the roll?
Mayor Ostenburg.
Aye.
Trustee McCray.
Aye.
Clerk McGann. Aye.
Very good. Rules of procedure are adopted. The first item to come before the Electoral Board is case number 1, which is the case of Jonathan H. Newman versus Emma Cox, 2019-PFMOEB-01. Mr. Attorney, would you explain the...
Sure. And just so everyone knows, it's 2019 PF Park Forest Municipal Officer Electoral Board, and this is case number 1. Are the parties present?
Scott Erdman, E-R-D-M-A-N, on behalf of the objector.
And for the record, Mr. Erdman has just filled out his appearance form and has submitted same to us. Is Ms. Cox here?
Ms. Cox here? Emma J. Cox? Emma J. Cox? Emma J. Cox? Ms. Cox appears not to be present.
Then we'll proceed with the board, the board adopting its exhibits, and as well as in this case there's a case of withdrawal, which will also accept as
Okay, very good. Then at this point, have the members of the board had the opportunity to reveal the objector's material?
Yes.
Okay, very good. Then I would ask that these exhibits, a motion be put in order to adopt these exhibits. Is that the proper word?
Yeah, and I can go through each exhibit
Okay.
if you'd like. We'll call
Let's have the motion first, and then as part of the discussion, you can explain each one.
Okay.
Is there a motion?
So moved.
Second. It's been moved and seconded to adopt the exhibits. Now, Mr. Attorney, would you explain each one of them?
Sure. For the board's exhibits, we'll label board's exhibit 1 will be the objector's petition filed in this matter. Board's exhibit number 2 will be the calling for this electoral board. Exhibit 3 will be the candidate's nomination papers. Exhibit 4 will be the agenda issued for and posted for this initial hearing. Exhibit 5 will be the proofs of service, waivers of service, and the appearances filed by any of the parties. And Exhibit 6 will be the rules of procedure just adopted by this board. And then as we would need this motion to pass in order to accept those board.
Very good. We have a motion and a second. We've heard the explanation. Are there any questions from members of the board? Then let's move to the vote. Will the clerk please call the roll?
Mayor Ostenburg.
Aye.
Trustee McCray.
Aye.
Clerk McGann. Aye.
The motion passes. So the exhibits are accepted into evidence. The next item is to set the schedule for motion and arguments. Mr. Attorney?
Well, in this case, the electoral board should also note that the village clerk's office, I believe, received a withdrawal of candidacy form submitted by the candidate. And so it would be my recommendation to first move to adopt that into evidence as Board's Exhibit Number 7, and then if the board feels comfortable that you can vote on this matter with the decisions to follow the next year.
Very good. Is there do you have a copy of that? So before the board is a withdrawal of candidacy initiated by Emma J. Cox, 5 Rich Court in Park Forest, Illinois, Tommy Cook. It relates to her nomination papers for the office of mayor. Ms. Cox has signed this. It looks as though it was signed on and notarized on the 26th of December 2018. So as such, she withdraws her candidacy for election to the office of mayor. Is there a motion to accept this withdrawal of candidacy as evidence?
Mr. Mayor, I make a motion that we accept this evidence.
Thank you.
Second.
It's been moved and seconded to accept this withdrawal of candidacy as put it into the record as evidence. Is there any discussion? Then will the clerk please call the roll?
Mayor Ostenburg.
Aye.
Trustee McCray.
Aye.
Clerk McGann. Aye.
Okay, very good. So, Mr. Attorney, at this point then, we would set a specific time to hear on this matter?
Correct. And we would have a full decision prepared that could be voted upon. It needs to be signed in open session. It would be assigned then. If you want, you can vote on these objections now, or you can simply vote then. And it would be our recommendation to grant the objections or to decide that the objections are moved given the withdrawal.
Okay, very good. I would suggest that we declare the objections moot, given the fact that the candidacy has been withdrawn. Is that agreeable? Was there a motion to that effect?
I would make a motion that we accept the agreement as moved.
Second.
Been moved and seconded that we declare this particular item as moot, given the fact that the candidate in question has withdrawn her candidacy. Is there any discussion on the motion? Will the clerk call the roll, please?
Mayor Ostenburg.
Aye.
Trustee McCray.
Aye.
Clerk McGann. Aye.
As such, that then is declared moot at this point. We'll move now to Electoral Board case number 2. This is a case of, yes.
I want to set this for
Okay.
next week to come back to decide the decision.
Okay, very good. We will formally then establish the decision at a subsequent meeting. Looking at calendars, I think we have decided that the best time for that subsequent meeting would be at 9:30 a.m. on Thursday, January the 10th. Is that agreeable? Is there a motion to that effect?
Mr. Mayor, I move that we accept the date of Thursday, January 10th as the next meeting date.
9:30 in the morning?
9:30 a.m.
Very
Yes.
good. Second?
Second.
It's moved and seconded to set the date for the board to reconvene at 9:30 a.m. on Thursday, January the 10th, 2019. Is there any discussion? Clerk, call the roll.
Mayor Ostenburg.
Aye.
Trustee McCray.
Aye.
Clerk McGann. Aye.
Very good. That motion then passes. We will now move to Electoral Board case number 2. Mr. Attorney, do you want to?
Sure. Case number 2 is Jonathan H. Newman versus Sean P. Hightower, 2019 PFMOEB 02.
And do we need to have a
We do reach,
Okay.
we have to adopt the rules.
Okay, very good. The attorney has explained to me that under the dictates of the law, we need to have a roll call for each one of the cases that we hear, and we need to adopt the rules again for each one of them. So as such, will the clerk please call the roll?
Mayor Ostenburg.
Aye. Here.
Trustee McCray.
Here.
Clerk McGann. Here.
Very good. And on the adoption of rules, is there a motion to adopt the rules for this particular case?
Mr. Mayor, I move that we adopt the rules as pertaining to this case.
Second.
Moved and seconded to adopt the rules. Any discussion? Will the clerk call the roll?
Mayor Ostenburg.
Aye.
Trustee McCray.
Aye.
Clerk McGann. Aye.
Very good. The rules of procedure are adopted. We will now the attorney now will proceed with the details.
Sure. This is Newman versus Hightower. Are the parties present? Could they step forward?
Yeah.
Sir, could you come forward?
Scott Erdman, ERD-MAN, on behalf of the objector.
And for the record, Mr. Erdman has submitted his appearance on behalf of the objector. It's just filed a couple minutes ago. And then Mr. Newman, or Mr. Hightower, sorry, is here filing his appearance as well.
Very good. And then,
Excuse me, did you provide him a copy of mine, and can I get a copy of this?
What we can do is either make copies, or what I'll do when I get back to my office
Thank
is I will scan these and email them to both parties, if
Thank
that's agreeable to Mr. Hightower as well. I'm gonna scan how to contact objector's attorneys, and I'll send everyone's appearances to everyone.
Thank you.
very good. So let's, first of all, let me have a motion to accept the exhibits.
Mr. Mayor, I move that we accept the exhibits as presented.
Second.
Moved and second to accept the exhibits. Is there any discussion? We'll move to explanation by the attorney.
Thank you, Mr. Mayor. The electoral board's exhibits, similar to the previous case, would be as follows. Exhibit 1 will be the objector's petition. The board's exhibit 2 will be the call for this electoral board. The board's exhibit 3 will be the candidates' nomination papers. Board's exhibit 4 will be the agenda for this initial hearing. Exhibit 5 will be the proofs of service, any waivers of service, and appearances filed by the parties or on their behalf. And exhibit 6 will be the rules of procedure just adopted in this proceeding.
Very good. Any discussion of those? Okay, then on the motion, we'll call the roll.
Mayor Ostenburg,
Aye.
Trustee McCray,
Aye.
Clerk McGann, aye.
Very good. Then the exhibits are accepted as explained by the attorney. We'll now set the schedule for motions and arguments. Mr. Attorney?
I guess in this case, after my review, it seems that the issues raised would be described legal in nature, unless either party disagrees. It would be my recommendation that we set a briefing schedule pursuant to the rules. Mr. Hightower, you have the opportunity to either file a preliminary motion in the form of what would be a motion to strike and dismiss, or we could just set this for pure briefing on the legal arguments. It's really your choice as well, as long as my thought of the case is correct. That this case will not require a records examination or any review by an election authority of individual voter registration records. Is that correct?
That's correct, sir.
Is that your understanding as well?
Yes.
Okay. So if we want to set a briefing schedule, if you can file, are you planning on filing any sort of preliminary motion to strike or dismiss this case?
I'm just here to present my argument.
If we can, we'll set it for, what we usually do is, if you could submit something in writing, and then we would, for the board to have, and then at the next hearing, you will present an oral argument in addition to that. If anything, it could be the cases you're relying on, or the law that you're relying on.
So what's the point today?
The date that we considered previously for continuance on the Cox case is 9:30 on Thursday, January 10th.
Okay.
Would that be an acceptable time to you?
Not really, but I mean, I thought today would be the day to present all of this. It's very short, to the point.
Well,
I do have a job.
I think if it's his desire to have the case heard today, I think providing the attorney for the other side is ready to proceed, I think we should hear the case today. Are you ready to proceed?
Yes, we'll proceed. That's fine.
Okay, very good. Then let's see. Do you need a formal? You have the material from Mr. Hightower. You have the material from the challenger's attorney. So we accepted the exhibit. So at this point, then, who argues first?
I believe it would be the objectors then.
Okay, very good. Proceed.
Okay.
Good evening, or excuse me, good morning, members of the board. Mr. Hightower has filed his nominating petitions, and on each and every petition sheet, he has failed to place his place of residence, his address on those petition sheets. That's required by section 10-4 of the election code. And it says that, that states that the petitions for nomination shall contain above the space for signatures, an appropriate heading giving the information as to name of candidate or candidates in whose behalf such petition is signed, the office, the party, place of residence, and such other information or wording as required to make same ballot, and the heading of each sheet shall be the same. So the 10-4 requires that the petition shall have this place of residence. The form used by the candidate even labels the box contained in the heading and above the space for signature as address-zip code. The candidate is to provide his residence address above the place for signature to inform the signers of his petition that he resides within the jurisdiction for which he's running for office. The use of shall within the statute indicates that this is a mandatory provision of the election code. This isn't something that you can substantially comply with or even ignore, as in this case. His failure to comply with the mandatory provision renders his nomination petitions invalid. Specifically, the Poche case, Poche versus Cook County Officers Electoral Board, 628 Northeast 2nd 258, dealt with this question of address, although it was under an objection that had been filed. The objector failed to state her full address. And quoting Poche, Banks affirmatively responded by moving to strike and dismiss the objector's petition. He alleged that the objector's petition did not meet the requirement of section 5/10-8 of the Election Code of Illinois because the petition failed to state her address. In this regard, the record establishes that Poche's objector's petition alleges the objector resides at 11006, Chicago, Illinois, zip code 60655 in the 28th representative district of the state of Illinois and is a duly qualified and legal and registered voter at that address. Does the objector's petition conform to the pertinent provisions of section 10-8 of the election code? We answer this question in the negative. So the court took a look at this objector's address, and it's the same type of requirement. You have to place your address so that you inform the voters that you're a resident of the district that you're running for office in, so that they know that you know that you're coming from within the jurisdiction. They found that she had failed. She put her house number, her city, her state, her zip code, and the representative's district. She left off the name of her street. Now, the court found that just the name of the street missing was a fatal error to this woman. Here we have a complete lack of house number, street address, village or city, and are merely provided a zip code. Now, the zip code provided can be applied to both Park Forest and University Park. So it's not even a question of, hey, this zip code is all in one municipality and therefore it should stand. I think that would fail under the Poche decision, but even that doesn't provide any interested registered voter within the district of that information. So the candidate has failed to comply with the election code. His petition should be stricken.
Thank you.
Thank you.
Mr. Hightower, do you have a response?
First, I want to say thanks to the Village of Park Forest Municipal Officers Electoral Board for helping create a fair election for the wonderful citizens of Park Forest. Also want to extend condolences of my supporters and I to the family of Mayor John Ostenburg on the loss of Miss Lena. We wish you and your family nothing but the best. Also want to thank our residents, John H. Newman and Christine Dupee, for allowing me not only to argue my case, but to also uphold the tremendous amount of support I have garnered over the past 7 weeks. So I'm here not to share my intent, I'm only here to illustrate attention to detail, which is listed throughout my nomination papers. For the record, I want everyone to know that I was the sole circulator for my petitions and did not seek or receive any help when completing my forms, getting signatures, and filing my papers. And I just want to ask the board, do we have a statement of candidacy filed for Prashanthi Hightower, form SBEP1B?
Yes, we do.
Okay, and is there an address listed for said candidate
On the candidate's form, is my
on the
understanding.
statement of candidacy?
Have that printed?
We have the originals with us, but, the copy. And that has been previously marked as, board's exhibit, I believe.
And it does show your address at 438 Tamarack Street on the statement of candidacy.
Okay, and how many times is the address listed?
Excuse me, are we gonna have the candidate examine or cross-examine the board? This is his time to make his argument, not to question the board.
I didn't think he was, I interpreted what he was doing was just making sure that the material he submitted was accurate. Is that, am I misunderstanding, Mr. Attorney?
I was gonna let him go just a little bit, but.
Yeah, as long as it's a case of establishing the accuracy of what we have, I think we could do that. If he starts to question us in terms of cross-examining, I think that's a different matter. So we will be attentive to that, so thank you. Mr. Hightower?
And how many times is the address listed?
Now he's asking the board to examine the document.
This is the
and
first
ask-
part of me stating my address all throughout the nomination papers. This is the first step, this is the first point I'm trying to make as I submitted and did a loyalty oath for the Village of Park Forest. I'll get to where my point's going, but this is the start.
The only thing I would say, Mr. Hightower, is that, from the way that I heard the objection and what I read as the objection was not to your statement of candidacy or to your loyalty oath. The objection was specifically to the petitions that you circulated, on the context that the people who signed those petitions had no indication from you that you were a resident of the village. So I think if you address that point,
Okay.
the others, to my way of thinking, really aren't relevant.
I got it. Okay, so for the record, for those listening and viewing, we already said what address is listed for said candidate. How many counties cross Park Forest's city limits?
Well, again, I think that, you're asking a question.
This is what I'm getting to.
Very
because
obvious.
We're saying that
We are located in 2 counties. The
Okay.
municipality is located predominantly in Cook County and a portion in Will County.
Okay, thank you. And is University Park a part of Park Forest?
I'm gonna object again.
No,
He
because
can
we're
make
going
his
over the
argument,
zip
he's
code.
not here to question the
We're
board.
arguing over the zip code, the 60466.
Are you trying to establish evidence to support your
Yes.
case? Then what I would suggest that you do is, rather than asking it in the form of a question, that you present it in the form of a statement.
Okay,
In other words, for you to say, University Park is not a part of the Village of Park
Okay.
Forest.
all right,
Clear.
let's move on. All right, so University Park is not a part of Park Forest, and no qualified voter living as a Park Forest resident can vote for a University Park official. No qualified voter living as a University Park resident can vote for a Park Forest official. Of the qualified voters signed and listed on the petition sheets, does anybody see any inconsistency within the city, town, or village column in which the qualified voters of Park Forest sign those signatures?
Again, I think you're asking a question,
Okay.
should be.
Okay, so there's no inconsistency within the city, town, and village. All the signatures show Park Forest all throughout the signatures. Now, let's circle in on the petitions that were seen by qualified registered Park Forest residents of both Cook and Will County. On the prefatory section of each ballot, it states, "We, the undersigned qualified voters in the village of Park Forest in the county of Cook/Will and state of Illinois do hereby petition that the following named person shall be an independent candidate for election to the office hereinafter specified to be voted for the consolidated election to be held on April 2nd. So this is consistent on every single page above where it shows my name, the office, and the zip code. Also, on the bottom of every petition page, it shows my complete address, the 438 Tamarack. And on the petition, this body of words is at the top of each individual petition sheet. So anybody that would have signed these petitions, that would have been the first thing that they saw, was Village of Park Forest, we the undersigned, Prashanthi Hightower, Mayor, 60466. Now, where I found some ambiguity with the address zip code, because I've done, petitions for other candidates, people running in other offices, and on those petition sheets, it's a standard to have it listed as address, ampersand, zip code. Again, this is my first time running for public office. This is my first time seeing address hyphen zip code. I've gone to college, I've done many exams, so seeing an address hyphen zip code, to me, again, without any help from anybody, me being the sole circulator, I'm thinking this is the zip code of my address with the hyphen, okay? Now, all throughout the petition pages, again, whether it's page 1, or page 2, page 5, it's all consistent. There's no backside to the petitions. My full address is listed everywhere. And for Mr. Newman, I was just wondering if he had any evidence of any of his neighbors living at 200 Lee Street, 202 Lee Street, or 204 Lee Street, because these were people that actually signed my petition, and I don't think that they were confused by any of this when they signed my petitions. And I was wondering, do we have any affidavits from any qualified registered voter of Park Forest showing that they were confused by any way the 60466, seeing that on the petition? So, Your Honor, I'd like to bring up docket number 03 EB ALD-106, if you will.
Do you have a copy of that?
Yes.
Okay.
Is there a copy for the objectors, counsel?
It seems like I only got one. For the record, I've been handed a findings and decision of the Board of Election, the findings and decision from the Board of Election Commissioners for the City of Chicago as the duly constituted Electoral Board in the case of, in their case number 03 EB ALD 106. It's Mitchell et al. Versus Bolden regarding a candidate for the office of alderman of the 4th Ward in the City of Chicago. And I believe did counsel for the objector proceed? Got to?
Yes.
Proceed, Mr. Attorney.
So in section 15 of this section, so same issue.
Just before we move on, you have 2 pages of this?
Is there any way we can make a copy of this or no?
Is that permissible? John, could you guys make a copy, please?
And this case was in 2003. And the gist of this,
If
I
we
mean, there was.
could, if we could wait till.
Okay, we can wait.
Okay, very good. We will,
Discussion.
we will wait until the copies are made.
Oh, sure. Yeah.
Yeah, you can do that at this point. Yeah. Do you have the copies? Oh, okay, so you have a copy now?
Yes, I have.
Okay, let's continue then, because we will reconvene at this point.
So here's a case where Holden was running for district alderman. And if we go to section 14, one of his objections from one of his objectors was the whole address issue. And with the address, if there was anything wrong due to the Board of Elections, the state code, I guess she's supposed to throw it out. But here it says, section 14, as regards the issue of the candidate's address as it appears on his nomination papers, the hearing examiner found that on all 136 of the candidate's nominating petition sheets, the candidate stated his address at the top of each sheet as 4318 South Berkeley, 60653. The city of residence is not mentioned. The hearing examiner also found that the address box in the candidate's statement of candidacy also recited the candidate's address as 4318 South Berkeley, 60653. The candidate put on evidence by stipulation and unrebutted testimony that the number 60653 contained in the residence box was a zip code which only referred to an address located in the 4th Ward of the City of Chicago, and that mail addressed in such a fashion would in all probability arrive at the address. It goes on to say on 15 that section 10.4 of the election code provides in part that petitions for nomination shall contain above the space for signatures an appropriate heading giving the information as to name of candidate or candidates in whose behalf such petition is signed, the office, the party, place of residence, and such other information or wording as required to make same valid, and the heading of each sheet shall be the same. Moves on to section 16, where the candidate argued correctly that this electoral board held in Tenter versus Ortiz, docket 95 EB ALD-077 in 1995, that the candidate there substantially complied with section 10.4 when the petition sheet headings listed only the street number and name, but failed to list the name of the city of residence. Here, the candidate's full resident address, including his city of residence, can be found in other places within the candidate's nomination papers. His city of residence appears in the circulator's affidavit at the bottom of approximately 54 petition sheets that the candidate circulated, as well as on the candidate's statement of candidacy. There was no evidence presented that any of the voters who signed the candidate's nominating petition sheets were confused about his residency. Thus, the electoral board finds that the candidate substantially complied with the requirement in section 10.4 that the candidate's resident address be stated in the heading of the candidate's nominating petition sheets. And then finally, the electoral board finds that the failure of the candidate to include his city of residence in the heading on each of his nominating petition sheets is not fatal and does not invalidate the petition sheets. Therefore, the electoral board overruled this objection and finds nomination papers valid.
Is that, do you have anything further, or is that?
That is all matters.
Okay. Anything on any of the other matters that you want to address at this point?
This is just Newman, right?
Yes.
That is all.
Okay. Would you like to offer any comments?
The candidate's right on one point. The petition sheets are consistent. Unfortunately for him, they're consistently wrong. Okay? He can wonder about voters all he wants. He can ponder whether somebody could have brought affidavits in, and he can suppose whether or not someone was or wasn't confused. What we have here is a requirement that's a mandatory requirement that he place his address in the box. Now the candidate would have you look to the form that he used, where it says, "We, the undersigned, qualified voters in the village of Park Forest, in the county of Cook/Will, and the state of Illinois, do hereby petition that the following named person shall be an independent candidate for election to the office hereinafter specified to be voted for." Right in the paragraph above it that he's relying on, it's indicating that he needs to fill out the boxes below. And one of the boxes that he needed to fill out was his address. Now, he can also point to the first person who signed his petition sheet as being somebody from Park Forest. Well, the very first person that signed his petition sheet had no information on his address. The second person, no information on his address. All the way down, 1 through 10. None of those people had any information on his address, and the code requires that. And any attempt to point to his address in the circulator's affidavit is of no point. It's of no consequence, because the address in the circulator's affidavit is filled out after the last person has signed this petition and when Mr. Hightower was in front of the notary. Had he filled that out and signed it prior to any of these people seeing it, then the petitions would be thrown out because he had it notarized prior to their signatures. That appeared after his signature, after he collected these signatures. Now, he mentioned that the city's case, okay, which runs contrary to an appellate court case. The appellate court case here, it was very specific about what's required of an address, and the city's decision runs counter to it. And the only reason that I would say that the city's decision runs counter to it is because it was a Chicago Board of Elections case, where all cases heard by them are for offices within the election authority of the city of Chicago. The candidate in this decision was running for an aldermanic position, which by definition is within the city of Chicago. So the fact that the candidate, Mr. Bolden, put a partial address in there, not just a zip code, put a partial address in there, 4318 South Berkeley, 60653, with City of Chicago, Mayor, Alderman, City of Chicago, those read together could be, were there to inform the voter of where he lived, and that he lived within the jurisdiction. Here we don't have that. Here we have a zip code that can be used for Forest Park or University. So, I'm sorry, Park Forest, I apologize. It's one of those things where I told myself, don't say it wrong, don't say it wrong, don't say it wrong, thus guaranteeing.
You're
that I
among
would say it
thousands
wrong.
who do it,
So, I apologize. So there is no clarity, there's no specificity, there is no compliance with the election code, and Poche absolutely distinguishes
What
the
city
city
is
of
Poche?
Chicago.
Please don't interrupt.
It absolutely distinguishes the city of Chicago case, which is specific to a fact pattern that only arises in a Chicago Board of Election case.
You finished?
Yes, sir. Thank you.
Hightower, you have a
So
response to that?
I like to counter, how does he know in what order my address was listed at the bottom? For the affidavit purpose, for the notary, all you have to do is sign. All they're looking at the information on there. So I don't understand when he says that I wasn't walking around with petitions with the prefatory section and the address section signed, not signed, but with the address section in there. Like, how do you know that I did not walk around? You just made the notion that I signed all this information, my address information in front of the notary, which is actually incorrect. Also, the case that you referenced, you said the case was the docket is the city of Chicago, but here you are talking about Poche or Poochie, which is the city of Chicago. So what relevance are you making with that?
The Illinois Appellate Court.
Please.
Okay, sorry he asked me a question. So.
And like I said, if there's no evidence that none of these people that filled my petition were confused by any of this, then I think these petitions should remain valid.
Is it sufficient to have each one, or do we need a little further back and forth? Yeah, I think a couple of things that I would ask for clarification before the members of the board have any questions. One is, can you, as the attorney for the board, can you give us an explanation of what takes precedence, a court case or a local electoral board ruling?
Yeah, thank you. How case law works in Illinois and the United States generally is that obviously the Supreme Court is the highest authority. Any Supreme Court case takes precedence over any others. Then comes any appellate court. Illinois, the state law matters. It would be the Illinois appellate court takes precedence over any other lower courts, but the Supreme Court takes precedence over that. Then any circuit court is under that, and so appellate courts, the Supreme Court doesn't have to follow the circuit court or anything else that's lower than them, but they can look to it just for reference purposes, but they don't have to follow it. But whereas the circuit court, for example, must follow the precedent from all the appellate courts and all the Supreme Court and the Supreme Court, and then this body is an electoral board, or in the case of the Chicago Electoral Board, is actually an administrative body, which is below circuit courts. So the circuit courts there are standards of review, but they are not bound at all. Neither the circuit court, appellate court, or Supreme Court are bound in any way by the decisions of an electoral board or administrative body to have to rely upon them for future decisions. And then on top of that, this board can look to other administrative boards, the other electoral boards, for guidance as to how to interpret something, but is in no way bound by those decisions, whereas this board is bound by circuit court, appellate court, and Supreme Court precedent.
And then secondly, as relates to the use of an address on the form, is the law specific in terms of what needs to be included?
Section 10-4 of the election code, which is applicable here in this case, requires that the petition sheets bear a heading that contains, what's important here is the place of residence for the candidate.
And that is stated specifically in the law, that it has to be the place of residence.
Place of residence, and then further that section 10-4 does state specifically that no signature shall be valid or counted in considering the validity or sufficiency of such petitions unless the requirements of this section are complied with. So not only is there a shall requirement, a mandatory requirement, but there is a penalty provided in this section.
Questions from the other members of the board? Trustee McCray? No question? Clerk McGann? Then I would ask Mr. Hightower, do you desire to have the board vote on this today? Or would you like to further develop your argument and come back next Thursday as we earlier stated?
I mean, I'm all in at this point. You make a decision today again. Grew up in Park Forest, 1986. This was my chance to shine. So if somebody wants to tarnish my dream of being mayor of Park Forest, then albeit. But I tried my hardest to represent the people of Park Forest to my utmost ability.
Are we prepared then to move to comments from the board on the issue? Yeah.
And then next time we'll have a written decision.
Okay.
Finality for appeal purposes.
So I would ask at this point, Clerk McGann, do you have anything that you would like to offer in terms of your position on this matter?
After hearing what the law states, and it says specifically residency, I would say that the address would have to be included.
Trustee McCray?
I would say that, in looking at these forms, looking at the independent candidate petition sheets, and noting that in the far right-hand box, it does indicate address, dash, zip code, that dash presumably indicates in addition to the address, there's the zip code. It is not present, and so I would have to go along with the rulings of state electoral board.
I have to say, Mr. Hightower, I'm very sympathetic to your situation. You know, I've had my petitions challenged twice, and I know what it's like. You know, you go out and you do all that work, and you know, you try to get the very best information possible, and then all of a sudden you're facing something that you had not anticipated that kind of came out of the blue. That being said, I think that it's incumbent upon the electoral board to follow the letter of the law, because in effect, if we don't, whatever decision we make can be reversed on appeal, given the fact that the law is in place. You had your chance before. And the case in Chicago, I think, you know, I think there's two situations there that we as an electoral board have to give attention to. One is that it was the electoral board of the city of Chicago, so it relates to an incident in the city of Chicago. We're the electoral board of the village of Park Forest. Since electoral boards are, as the attorney explained, the decisions of electoral boards can be utilized for guidance, they're not binding on us, whereas state law is binding on us. So we have to look to the state law. You know, I think had you had your address on there, you know, the address on the line, and then failed to put the city of Park Forest, but you did have the zip code, I would be more inclined to say, you know, substantially, the people who signed your petitions had a clear indication of where you lived. I mean, to me, that would be, you know, the fact that you might have left the city off, but had the zip code and the street address, I think I would probably follow the same thinking as the folks in Chicago did with that case, where the combination of the street address and the zip code makes it clear-cut in terms of where you live. But I think under the circumstances where there was no street address given at all, it kind of ties our hands in my mind, and that we have to rule in favor of the objection. So I will at this point ask the clerk to call the roll, please.
Mayor Ostenburg,
Aye. Oh, wait, first of all, we didn't have a motion, so I'll need a motion to in fact reject to accept the objection.
Mr. Mayor, I move that we accept the objection. Yes.
second.
It's moved and seconded. Is there any discussion on that? Okay, then clerk, please call the roll.
Mayor Ostenburg,
Aye.
Trustee McCray,
Aye.
Clerk McGann, aye.
Okay, very good. The judgment of the electoral board is that in the case of Jonathan H. Newman versus Sean Hightower, that in effect the petitions were invalid by virtue of the fact that the information required for the addressee of the candidate is deficient. We will move now.
Just to note, the formal decision will be prepared and presented next week. And then for appeal purposes, that's when the clock is.
Very good. So the, as the attorneys just mentioned, we will have the formal presentation of the decision at next Thursday morning's meeting, and at that point, we'll move forward on things. Next case is that of Jonathan H. Newman versus Renee Hightower. I'm sorry, Renee Hawthorne. Do I have the... Oh, need to put on the right glasses so that I read things correctly. Very good. Again, we will have to go through the formal process of calling this particular hearing to order, and will the clerk please call the roll?
Mayor Ostenburg,
Here.
Trustee McCray,
Here.
Clerk McGann, present.
And secondly, may I have a motion to adopt the rules of procedure as in previous?
Mr. Mayor, I move that we adopt the rules of procedures.
Second.
Moved and seconded to adopt the rules of procedure. Any discussion on that motion? Will the clerk call the roll, please?
Mayor Ostenburg,
Here, yes?
Trustee McCray,
Yes or aye?
Clerk McGann, yes.
Very good. Getting confused on all of our responses here. Okay, now, at this point then, we have all of the appearances have been filed appropriately?
Just the objective,
You don't have an appearance from Ms. Hawthorne?
not yet.
She has.
Oh, And like the last case, I'll scan the appearances of the objector's attorney as well as candidate Hawthorne's, and I'll just email it to everyone.
Thank you.
Very good. Okay, what I would like to have then again is a motion to accept the exhibits.
Mr. Mayor, I move that we accept the exhibits as presented.
A second.
Moved and seconded to accept the exhibits. At this point, I would ask the attorney to detail what those exhibits are.
Absolutely. For this matter, like in the previous matters, the board's exhibit number 1 will be the objector's petition. Board's exhibit number 2 will be the call for this electoral board. Board's exhibit 3 will be the candidate's nomination papers. Board's exhibit 4 will be the agenda for this initial hearing. Exhibit 5 will be the proofs of service and the waivers of service and the appearances filed by the parties or on behalf of the parties. And board exhibit 6 will be the rules of procedure just adopted.
Very good. And I would ask if the members of the board have had a chance to review the various exhibits.
Yes.
Yes.
And then on this matter, are there any questions regarding this motion? Okay, then please call the roll.
Mayor Ostenburg,
Yes.
Trustee McCray,
Yes.
Clerk McGann, yes.
Very good. The exhibits are accepted as evidence. We will now move to setting the schedule. Ms. Hawthorne, I would ask, first of all, Do you want this case to be heard today, or would you like to have more time and have it heard next Thursday when we reconvene?
I'd like time for next Thursday.
Okay, very good. And the attorney,
Yes, is there an actual briefing schedule that the board wants to set?
will you set that?
Yes.
The attorney will work with the two parties.
So,
Oh, you do it now? Okay.
So in this matter, pursuant to the rules, Ms. Hawthorne, you have the right to file what's called a preliminary motion, whether it's a motion to strike and dismiss or anything that attacks the legal sufficiency of the objection itself. Alternatively, we can just set a time for the parties to file legal memorandum that argues the points. It's my understanding that this objection is, we'd say, legal in nature, in that all of the issues raised, I believe, or this actually does have this has both legal issues as well as
Line by line.
line by line objections to individual signatures, which will require a records examination. So first, we can set the briefing schedule for any preliminary motion and legal memoranda, and then we can also, and it would be appropriate to move to direct this matter for a records examination.
Very good. Could you just advise the board and the other parties, what exactly is the time limits that we have on this matter relative to the date of the election?
Obviously, the election is April 2nd, which is really not that far away. I believe that this matter, we have a little bit of wiggle room, but really needs to be done
Expeditiously.
very expeditiously.
Okay.
You know, no later than really the very end of January, very, very late. So that's why.
Just so that we know what the parameters are in our thinking.
And, yeah.
Okay, so then, in terms of the records examination, the process for that is?
It is Rule 6 of the rules. I mean, I strongly advise to really look at those carefully. They are very similar to the rules, like I mentioned before, of Cook County and Chicago, and how they could conduct these types of examinations. And that process will be that this board will refer this matter to both the Cook County Clerk's office as the election authority for Cook County, and then if there are any Will County signatures, that election authority, the Will County Clerk's office will have to handle that portion of the records examination. And the representative from their office will go through and make initial determinations, or a representative of this board, frankly, could make initial determinations, which then can be presented for argument at either the next hearing or assuming that the records exam is completed by then.
Are there any time constraints on the two respective county clerks that they have to deliver the material by a certain time after requested?
No, nothing's specifically required, but they tend to be very good about, especially Cook County is very good about, they know how to do these, and et cetera. Will County, we'll have to, my office can coordinate with the new clerk's office to make sure that they're ready. I've had it both ways with them in the past, where they actually send you records, or they have people come in and actually conduct the exam.
I get you. Okay. So, just so that I understand procedurally, do we need a motion then to refer this to the counties for record check?
Correct.
Okay. Then is there a motion to that effect?
Mr. Mayor, I move we, well, I'll just say so.
Second.
Okay, just for clarity, the motion is that we refer these matters to the respective clerks of Cook and Will counties to examine the record and provide material for us relative to the accuracy of signatures, et cetera, right?
Correct.
Okay, any discussion among the board? Then, will the clerk please call the roll?
Mayor Ostenburg,
Yes.
Trustee McCray,
Yes.
Clerk McGann, yes.
Very good, then we will refer those matters, the motion passes, we'll refer those matters to the clerks of the two respective counties. Is there anything further that we need to take as formal action?
We'll set the actual briefing schedule, so it would, usually with these, we set for a preliminary motion. Perhaps if you could file something by Friday at 5 PM.
It's coming Friday?
Yeah.
So that by January 4th at 5 PM,
And then-
that would be, she would file any written response to this material? Is that what she's
She could
expected
file,
to file?
or some sort of preliminary motion that seeks to attack the legal sufficiency of the objections itself.
Okay.
So how it's pled, how anything raised, and so that would be also found in rule number 5 of the rules that kind of talks about it.
Just to make sure that, you know, everything is done in a fair manner, if the candidate desires to seek legal guidance, is that ample time between now and Friday?
I guess, do you plan to retain legal counsel?
Absolutely.
Oh, do you just want time to be able to do that?
Please and thank you.
Okay, so will 5 o'clock on Friday, the 4th of January, give you sufficient time?
No.
Okay.
Maybe we can kind of continue this map.
I want to make sure everything is done fairly, so.
Yes. You have the absolute right to hire an attorney, so just want to make sure that you have enough time to hire an attorney and that attorney has time to file whatever is required to be filed, and then there's ample time to respond. So perhaps we should start with the records examination, and then we could set any legal memoranda briefings after that based on those results.
I would request that they run, you know, concurrently, and that if we extend the original Friday date till Monday, that would give the candidate another 2 days to seek counsel and have that counsel familiarize themselves with what the issues are.
I think that would be a reasonable concession on your part. So I would say the board then would consider the possibility of setting a deadline of 5 PM on Monday.
Your Honor, if I may, just based on the holidays and my attempt to actually obtain an attorney, I've been having some challenges concerning that. I'd like to ask for at least a week.
Is that,
My thought was to potentially have it so that on Monday, then there'd be concurrent filings of any legal memorandum, and then you'd have till Wednesday to file a response on either side, and then Thursday would be here for hearing.
I would say that Monday is more than fair, and all parties interested here are interested in this moving, including the county.
members of the board have a feeling about the deadline? Trustee McCray?
Well, I'd like a little further clarification as to why the candidate, or to the candidate's argument that she doesn't have sufficient time.
Just based on the holidays, even when I went over to 69 West Washington, their dates were, the time was short, they closed at 1 o'clock that day. It is the holiday season. And so even myself, I've been off work for the past 2 weeks, and I've been having challenges absolutely obtaining an attorney. Not that I haven't reached out, I haven't received responses, and I'm believing that that it's inferring based on the holiday season.
But McGann, you have a feeling on this?
Just because we have to follow another timeline, I think, given Monday would be enough time. I know it's difficult with the days and the holidays, but because there's other timelines that have to be followed due to the election.
Okay. I can appreciate the fact that, you need as much time as possible, and I understand that. And I think we certainly want to be as accommodating as we possibly can. I can understand the fact that you may have had some difficulty during the holiday season. But you have work days of today, tomorrow, Friday, and all day Monday. And I think 4 complete work days plus a weekend to evaluate materials, I think is adequate time. And we have to, we can't draw this out extensively. So at that point, I would concur with the others that 5 o'clock on Monday would be the legitimate time and set as a deadline for the response. Now, if she makes her response, she doesn't have to have her attorney by that point.
No, no.
You could have your attorney later, and that's up to you. You just have to make your response to these arguments by 5 o'clock on Monday. Is there a motion to that effect? Sorry.
So any.
Yes, right.
Any legal memorandum.
Any legal
are due
memorandum
Monday.
from the other side also
And
would
then we
be.
could set Wednesday for any written response, and then of
Okay.
course, the parties are free to argue.
Okay, so just so everyone's clear, written response deadline would be 5 o'clock on Monday. And then you said oral arguments,
And any, any legal memoranda, either in opposition to the objection or in support of the objection, would be due at 5 PM Monday the 7th. Any written response, again,
those.
to those written arguments would be due Wednesday the 9th at 5, and then we'd be here Thursday morning at 9:30.
okay. So what I'm understanding from that is that when the written arguments are submitted at 5 o'clock Friday, they will immediately be copied and provided to the other side, and then the other side has until 5 o'clock on Wednesday to give responses to those. And then the arguments would be on Thursday morning. Is that reasonable? Okay, motion to that effect?
They would need to be served Monday at 5 directly to me
Yeah.
and myself directly to her and the
Yeah.
board. Okay.
Yeah.
I move that this board adopt the timeline as suggested.
Second.
Okay, any further discussion? Clerk, call the roll, please.
Mayor Ostenburg,
Yea?
Trustee McCray,
Yeah?
Clerk McGann, yay.
Very good, then that matter is set. Now, do we need now to move to case number 4?
If I could just to clear up something in the board. Since this is a dual county records exam, Rule 8 is the whichever county finishes last starts the clock on Rule 8.
Well, I think that what we'll do, so how Rule 8 is phrased, just so the board knows, the question is about, Rule 8 is the timing for filing a motion to preserve your right to appeal individual objections to signatures, and how each election authority makes a preliminary determination whether that signature is valid or invalid. Rule 8 is when you have to file a written motion detailing that information with the board and serve it upon the opposing party. That is usually due, per the rules, it is due no later than noon on the day filing the completion of the records examination. This case is unique in that the records examination may be completed in one county versus the other. So I guess it would be just probably easiest and fairest if it was the last county to finish.
Sure.
That's
Thank you.
the trigger of when everything was completed.
We don't need formal action for that, right?
No.
That's just, just so that you both know, it will be whichever county is completing its work last.
And as soon as we know about the scheduling, if it's okay with the board, that my office will schedule or kind of give the directive from this board to the election authorities. And as soon as we know anything about scheduling or when and where, we will provide notice to the parties.
Okay.
Then I have a question concerning records examination, number 7, concerning watchers. It would be then my responsibility, because they are dual, to make sure that there are watchers at each location.
We will work our best to make sure that they're not at the same time.
Thank you.
Thank you.
Okay, very good. Then now we will move to the next. Okay, we will, motion from the board to recess this case until 9:30 a.m. on Thursday, January 10th. Is there a motion to that effect?
So moved.
Second.
Moved and seconded. Is there any discussion? Clerk, call the roll.
Mayor Ostenburg,
Yes?
Trustee McCray,
Yes.
Clerk McGann, yes.
Very good. Then we will move now then to the case of, let's see, number 4 is So this is a case of Christine Dupee versus Sean Hightower. For the record, it appears Mr. Hightower is not here just now. Okay. We will move then to the usual procedures. First of all, I'd ask for we have to reconvene the hearing. Okay. Will the clerk please call the roll?
Trustee, I'm sorry, Mayor Ostenburg,
Here.
Trustee McCray,
Here.
Clerk McGann, here.
Very good. We will now need an adoption for a motion to adopt the rules of procedure as previously.
Mr. Mayor, I move we adopt the rules of procedure stated previously.
Good. Second. So moved and seconded to adopt the rules. Any discussion? Clerk, please call the roll.
Mayor Ostenburg,
Aye.
Trustee McCray,
Aye.
Clerk McGann, aye.
Very good. Rules of procedure adopted as previously. We will now move to introduction of the parties. Have you received the filing of appearances?
For the record, I have received the appearance of the objector, Christine Dupee. Am I saying it? Dupee, I'm sorry.
That's it. Sorry.
I apologize. And then Mr. Hightower was here in the previous matter, case number 02, and filed an appearance in that matter, but has not filed an appearance or attended his appearance for this matter. And so I will provide the objector the copy via email of Mr. Hightower's appearance, as well as I will scan to Mr. Hightower her appearance, but just for the record, he hasn't technically appeared in this case, and it seems
Okay.
like he left it.
Yeah.
Right.
Okay, very good. Then the next item would be a motion to accept the exhibits as evidence.
Mr. Mayor, I move that we accept the
Exhibits. Yeah.
as presented.
Second.
Moved and seconded to adopt the exhibits, and I'm presuming you both have had a chance to review them. Very good. Will the attorney now explain what those exhibits are?
Sure. Electoral Board's exhibit number 1 will be the objector's petition. The exhibit 2 is the call of this electoral board. Exhibit 3 are the candidates' nomination papers. Exhibit 4, the agenda for this initial hearing. Exhibit 5 will be proofs of service, waivers of service, and appearances filed on behalf of the parties. And Exhibit 6 will be the rules of procedure previously adopted.
Very good. On the motion, is there any question? The clerk call the roll.
Mayor Ostenburg,
Aye.
Trustee McCray,
Aye.
Clerk McGann, aye.
The exhibits are accepted as evidence. We'll move now to set the schedule for motions and arguments. Mr. Attorney?
Yes, in this matter, for the record, this is against the same candidate in case number 2, where the board just voted to sustain the objections against this candidacy. I guess it would be appropriate, and for the record, that the candidate himself, it appears to have left. I guess if the objection wants to state anything further, it would be appropriate to either find these moved, or if the objector wishes to present anything further in advance of the next hearing, just to preserve her objection in case the candidate ends up successfully appealing the other.
Oh, that's correct. So, Mr. Dupee, do you have anything you're feeling about that matter?
No, it's fine for two to be there.
Okay, very good. Then that being the case, is there a motion to declare this matter as moot, given the decision reached by the board previously on the candidacy of Mr. Hightower?
So
Second.
It's been moved and seconded that the board declare the objection of Christine Dupee against Sean P. Hightower as moot, based upon the fact that the board has already ruled on Mr. Hightower's candidacy. Is there any discussion of the motion? Will the clerk call the roll?
Mayor Ostenburg,
Aye.
Trustee McCray,
Aye.
Clerk McGann, aye.
Very good.
Just so you know, next, on the 10th, there will be a formal written decision that the board will deliberate and sign, and then that'll be served upon the party, and that triggers any appeal process.
So at this point then, can we adjourn this hearing? Okay, the motion to adjourn this particular hearing?
Mr. Mayor,
Yes.
I move to be adjourned this hearing today.
Second.
Motion has been to adjourn the hearing. Adjournment motions aren't discussable. I don't know why I asked for it before. Will the clerk call the roll?
Mayor Ostenburg,
Aye.
Trustee McCray,
Aye.
Clerk McGann, aye.
Very good. That hearing is adjourned. Now we will call the hearing of Christine Dupee versus Renee Hawthorne. And again, I would ask the, do we need to list the docket number, et cetera? I don't know that I have that from Okay, let's take a brief recess. Yes, no, not a problem. We will take a brief recess, and then we will resume. Hearing this is in the case of Dupee versus Renee Hawthorne. Did we adopt, we didn't do anything yet, did we, in this? Do we adopt the rules and call the roll? Had we adopted?
We did not.
Okay, very good. And the first item on the agenda will be the calling of the roll for this hearing.
Mayor Ostenburg,
Here,
Trustee McCray,
Here.
Clerk McGann, here.
very good. Next item will be the adoption of the rules, the same rules as we've had previously. Is there a motion?
Mr. Mayor,
Trustee McCray?
I move that we adopt the rules as stated.
Second.
Moved and seconded. Is there any discussion? Call the roll, please.
Mayor Ostenburg,
Aye.
Trustee McCray,
Aye.
Clerk McGann, aye.
Very good. We will move now then to the introduction of parties. Have the appearances been filed for the respective parties?
Yes, Mr. Mayor, for the record, the candidate, Renee Hawthorne, has filed her appearance, and the objector, Christine Dupee, has also filed an appearance. And just so the parties know, I will, as soon as I get back to my office, I'll scan them and send all appearances.
Okay, very good. Then, next item will be the acceptance of the exhibits as evidence. Is there a motion to that effect?
Mr. Mayor, I move that we accept the exhibits as presented.
Second.
And seconded that we accept the exhibits. Has everyone had a chance to look at those? Okay, very good. Then I'll ask the attorney at this point to describe the exhibits.
Sure. Just like the last cases, the Board's Exhibit 1 will be the objector's petition. Board's Exhibit 2 will be the call of the electoral board. Exhibit 3 will be the candidate's nomination papers. Exhibit 4 will be the agenda for this hearing. Exhibit 5 will be proofs of service, waivers of service, and appearances filed by the parties. And Exhibit 6 will be the rules of procedure just adopted.
Okay, very good. Is there any discussion of the motion after hearing the exhibits? Very good. Please call the roll.
Mayor Ostenburg,
Aye.
Trustee McCray,
Aye.
Clerk McGann, aye.
Very good. That motion passes. We will move now to setting schedule for motions and arguments. Mr. Attorney?
After a review of this, the objections filed in this case, it seems like these are more legal in nature than the other objection filed against the candidate in this case 3. This one, give the objector the opportunity to correct me if I'm wrong, but this is more specifically to individual petition sheets and raising, alleging legal issues with respect to same. And so I don't believe that this one requires a records examination with either the Cook County Clerk or Will County Clerk. Is that correct?
That is correct.
And, Madam Candidate, that's your understanding as well?
That is my understanding.
Very good. Then we can just move then right to setting the time for presentation for next week?
Yes.
Okay. Unless, Ms. Hawthorne, do you want you don't, do you want to hear this case today, or do you want it to be delayed?
No,
tomorrow?
I like the date for next week.
Very good. Okay, then, I will entertain a motion from the board that we recess this hearing until 9:30 a.m. on Thursday, January the 10th. Oh, yeah, okay. Then you have to explain that, right?
Sure.
Okay, to the two candidates.
These are, given the legal issues raised, it would be appropriate that, we previously adopted a briefing schedule for legal issues and other issues raised in the prior case. So for legal issues, it would be my recommendation that we set that similar briefing schedule for both the objector and the candidate to file a written submission memoranda with citing the principles upon which the objection, that they're relying for this objection. That initial brief would be due on Monday, January 7th at 5 p.m. Any response to the respective filing would be then due on Wednesday, January 9th at 5 p.m. And then, of course, we would set this matter for hearing and oral argument at Thursday, January 10th at 9:30 a.m.
Very good. Is there a motion to accept that schedule?
So moved.
Second.
Very good. Any discussion of the schedule? Then all in favor, clerk call the roll.
Mayor Ostenburg.
Aye.
Trustee McCray.
Aye.
Clerk McGann. Aye.
Very good. Then at this point, then, all we need is a motion to recess the board until 9:30 a.m. on January 10th, 2019. One of you?
I move that we adopt that date as stated.
Second.
Very good. The board, the motion then is to recess the board until 9:30 a.m. on Thursday, January 10th, 2019. Any, all in favor?
Aye.
Do I need to roll? Well, actually, let's do a roll on that, too. I want to roll on everything. So,
Mayor Ostenburg.
aye.
Trustee McCray.
Aye.
Clerk McGann. Aye.
Very good. And this hearing is adjourned. All five of